Yes, Mr. Stewart.
John, please. So, Dr. Applewhite, what we've gone through is that elders are appointed by the Holy Spirit. They are required to take the lead. Congregants entrust their lives to their spiritual lives to the elders. Elders exercise oversight over the congregation, and elders investigate and, if you like, prosecute allegations of wrongdoing. And I suggest the consequence of that is that the statement in paragraph 10 of your report, which says elders are viewed as fellow workers by their fellow elders and by the other congregational members, the other congregational members part is wrong.
You're being invited to respond to that.
Okay. Well, first, the distinction that I'm making here is the distinction between elders in the Jehovah's Witnesses congregations and, for example, someone who becomes an ordained minister in another organization. So becomes an officer in the Salvation Army, becomes a priest in the Anglican or the Catholic Church. And that distinction is what I'm pointing to here. I recognize that they are spiritual leaders, and in the list that you just gave, you said that they trust their spiritual lives to the elders. They trust their spiritual lives to the shepherding and guidance of the elders, but not intended to turn it over to the elders.
Well, Dr. Applewhite, a few things. Firstly,
may I just finish?
Yes, of course.
So that's just one piece of what you said that I wanted to mention. But the distinction that I'm making is the setting apart, and there's quite a bit in the literature about not lording over other people or being considered someone who's closer to God in any way or distinctive for the rest of their life. And so that's a distinction that I'm making, and there's no question whatsoever that they're in a leadership role, that they're trusted, and that they're meant to offer guidance to people, particularly about their spiritual lives.
Well, insofar as that's the point you're seeking to make, of course, there's nothing in that sentence or in that paragraph about comparing or distinguishing the Jehovah's Witnesses practice to anyone else. You're saying that in the Jehovah's Witnesses, elders are viewed by other congregation members as fellow workers.
Well, actually it says there is no particular sustained relationship between an elder and a circuit overseer the way there is with a pastor to a bishop in other organizations. So there's a reference to it, but you're right, I didn't make that specific point.
Well, that's the one point you make, and then you make a separate point, which I suggest to is wrong. They are the shepherds, they are not the sheep.
They are the shepherds.
Yes, not the sheep. They're not the fellow workers. They're not seen like that. Elders are not seen like that by the congregants.
So you're saying how the congregation members see them?
Well, I can't say that any more than you can in the absence of doing an empirical study, but using the materials you used, I say your conclusion is wrong. The elders are in a position of prestige, aren't they?
Prestige is probably not a word that I would see in their literature or the way that they would hope that an elder would present themselves.
They're in a position of honor.
It is an honor.
Yes. And it's, in many senses, the antithesis to fellow workers.
For me, what the elder is meant to present, or the elder is to present, is not the antithesis of fellow worker. It might be distinctive, but I don't see it as the antithesis.
And you mentioned that they're not closer to God. I mean, that's not right, is it? They're regarded as being appointed by the Holy Spirit. Elders are.
So you feel that makes them closer to God?
I would understand so, yes, but apparently you have a different understanding of closeness to God.
The literature just doesn't set them apart as distinctive or in some way superior.
Well, I will submit to the contrary in due course, but perhaps we can move on. If if we look at paragraph 18 of your report, you'll see it says that the elders are the local spiritual leaders of the congregations, and they offer spiritual guidance to congregation members on their own initiative or to those who ask for help. And it says they are the only members of the congregation authorized to provide pastoral care, which is meant to provide for the spiritual well-being of all congregation members. And then you make essentially the same point, although more specifically about ministerial servants in paragraph 20. Do you see it? You say ministerial servants are members of the congregation who provide non-pastoral practical assistance and service to the elders. And then you say ministerial servants are not authorized to provide spiritual guidance, counseling, or any other pastoral services to members of the congregation. So you say elders are the only ones who are authorized to do that, and ministerial servants are not authorized. Now, that's not quite right, is it?
Can you tell me how it's not quite right?
Well, the case that you testified in the United Kingdom, you gave evidence on precisely this point, and it was rejected by the judge, wasn't it?
I'm not sure that that particular point was rejected by the judge.
Well, perhaps we can take a look at the judgment.
So you're saying the point that ministerial servants are not authorized to provide pastoral care?
Yes. Or spiritual guidance, counseling, or any other pastoral services. Can we have it on the screen? Let me just look at the first page first. Okay, you'll see that this was 19 June 2015, the Honourable Mr. Justice Globe, and it set out between A and the trustees of the Watchtower Bible and Tract Society and the trustees of the Lonborough Blackbrook Congregation and the trustees of the Lonborough Southwood Congregation. But in particular, if we go to paragraph 16, which is at the...
What courts is this? This the High
This is
Court?
in the High Court of Justice, Queen's Bench Division. Royal Courts of Justice, the Strand. So you'll see paragraph 16 says, there is evidence in the case that ministerial servants are not supposed to have any independent pastoral or shepherding role. The evidence comes from a number of past and present elders, particularly Mr. Paul Gillies, who is a trustee of the First Defendants and a member of the British Branch Committee and an overseer. It also comes from Dr. Monica Applewhite, who has written a report about the structure and governance of Jehovah's Witnesses. She is an American expert in clinical social work, whose previous experience and expertise in relation to Jehovah's Witnesses is limited to being requested by the Watchtower Society to review 3 separate Jehovah's Witnesses civil liability cases. Whether or not a ministerial servant is supposed to have any independent pastoral or shepherding role is an issue in the case. Specifically, it is an issue whether Peter Stewart, he was the wrongdoer in that case, wasn't he?
He was
acting in any such role towards the claimant and her family at the material time. Insofar as reliance is placed by the defendants upon the organized book, Organized to Accomplish Our Ministry, chapter 6, pages 55 to 59, it is worthy of note that at page 56 it states, their work within the congregation generally involves non-teaching responsibilities. And at pages 58 to 59 it states, if there are not enough elders to conduct the congregational book studies, some of the more qualified ministerial servants are used as study conductors to care for assigned groups. They may be assigned to handle parts in the service meeting and the theocratic ministry school and to deliver public talks in the local congregation. Other privileges may be extended to some of the ministerial servants where there is particular need and they meet the requirements for the assignment. So that book referred to there was the pre-2005, pre-1991 manual for elders, wasn't it?
Yes.
And the 1991 and thereafter manual has essentially the same passages, doesn't it?
It does.
So if we have a look at tab 109,
Before we leave this,
yes,
so I think that you're asking me whether ministerial servants, if they are, what I've said is that they are not responsible for pastoral care.
you say they're
What's-
not authorized.
May I just continue?
Yes.
In here, they're talking about teaching and Bible study. There are many people who are authorized to teach, to conduct Bible study, and to take parts of the teaching role at the Kingdom Hall. And so this particular paragraph I just wanted to mention is about teaching and not about pastoral care.
Well, let's have a look at what the this particular subsequent edition states at tab 120.
Sorry. You say your paragraph is about teaching, is it?
The paragraph that is cited from the London case
That
is...
paragraph involves referring to non-teaching.
Generally, their work is non-teaching. However, they do have sometimes teaching roles, which, from my perspective, is different than spiritual guidance or pastoral care.
What's the difference?
So a teaching role for them would be standing up at a meeting and going through the watchtower, teaching a pre-assigned lesson, or in a home would be with a group of people overseeing a Bible study. And pastoral care would be someone coming and saying, I'm having trouble in my family, I need someone to talk to. And so that's the distinction that I'm making. When it comes to access or opportunities in analyzing cases, there's a distinction between the access that's provided by pastoral care.
Well, you'll see there that his lordship in that paragraph 16 specifically says that whether or not a ministerial servant is supposed to have any independent pastoral or shepherding role is an issue in the case.
Yes?
You see that? So that was an issue in the case.
It was an issue in the case, yes.
And if we have a look at, we'll just deal with it in order, 109, first tab 109.
Is that a different document?
Yes.
Okay.
At page 57.
Is this from the current version?
Yes, so what this is from is the document we showed you earlier, Organized to Do Jehovah's Will, 2005 onwards.
Oh, okay. Then I do need, wait, I have it already. Okay.
You'll see at the foot of the roll, foot of the page.
Mm-hmm.
Depending on local, so this is dealing with ministerial servants.
Right.
Depending on local circumstances, there may be other services that can be assigned to ministerial servants who are doing, as the Apostle Paul encouraged young Timothy, making their spiritual advancement manifest. If there are not enough elders to conduct the congregation book studies, some of the more qualified ministerial servants may be used as congregation book study servants to care for assigned groups. They may be assigned to handle parts in the service meeting and on the theocratic ministry school and to deliver public talks in the local congregation. Other privileges may be extended to some of the ministerial servants when there is a particular need and if they meet the requirements for the assignment. I suggest on the basis of that, there are circumstances in which from time to time ministerial servants are authorized to undertake pastoral care.
I haven't seen those circumstances.
Well, you haven't seen any circumstances, I understand it. You've done a review of the documents, not the practices.
I haven't seen examples that have been given in the publications or in the few cases that I have reviewed. I haven't seen a ministerial servant assigned to something that would be considered pastoral care.
Well, but you would accept that it's envisaged that the elders in a congregation may involve ministerial servants in pastoral care.
That's just not my understanding of their practices.
Well, leaving practices to one side, let's deal with what the documents teach them. I'm suggesting that on a reasonable reading of this, it's clear that there are circumstances in which an elder may authorize a ministerial servant to undertake pastoral care in a congregation?
So, since we're reading, the beginning of this section, they describe what ministerial servants normally do, keeping the Kingdom Hall clean and caring for the publications and so forth. And then they describe certain assignments or privileges that involve teaching. And my understanding is that there's a distinction for them between who is authorized to provide person-to-person spiritual guidance or pastoral care. That's my understanding.
But based on what?
Based on the reading of these publications and based on the examples that are given. It's very common in the publications that they will describe scenarios and give examples, and I've never come across that.
Perhaps we can look at the document at tab 120. It's the document Shepherd the Flock of God, which is the current elders textbook. You'll be familiar with it. Do you have a hard copy?
I have a copy.
And in particular at page 24. You'll see the first bullet point there. This is dealing with the a group overseer assists and trains ministerial servants in the group to reach out and qualify for congregation responsibilities. It is the best that another elder accompany him when visiting someone in the group having serious problems. However, he may select a qualified ministerial servant to accompany him when visiting publishers to offer encouragement, which will allow the overseer to observe how the servant reasons on matters. So the circumstances envisaged there is one of pastoral care, isn't it?
The ministerial servant would be being asked to consider what publications they might provide, what prayer they might provide, or if there's an experience he wanted to share. Yes?
And the ministerial servant would be involved in delivering that pastoral care along with the elder.
My understanding is that the elder would be providing pastoral care, and in certain occasions, maybe when they're considering someone to be an elder, might ask a ministerial servant to accompany.
And your understanding is based on, excuse me, what's written there?
For me, this is different than giving someone a pastoral care assignment.
Yes, but when you say it's your understanding, is that based on that paragraph there? That's your understanding of what that paragraph is saying?
That's what this paragraph is saying.
Yes.
If you just read the last sentence there, it says, afterward, the overseer reviews with the ministerial servant the reason the call was handled the way it was. So it's meant to be an observation and an instruction opportunity.
Well, it certainly doesn't exclude participating in the pastoral care itself with the elder.
It doesn't.
So I suggest that in paragraphs 18 and 20, where you say that only elders are authorized to provide pastoral care and that ministerial servants are not authorized to provide spiritual guidance, counseling, or any other pastoral services, is incorrect.
I could add to that with more detail, but I don't consider the statement itself incorrect.
And if we have a look at 21, your paragraph 21, you say in the last sentence, none of the responsibilities of a ministerial servant or elder allow or require that he be alone with children or otherwise separate a child from his or her family. Now that's not right in respect of allowing an elder to be alone with children, is it? There may be circumstances in which an elder is allowed to be alone with a child, isn't there?
Their own children?
Other children in the congregation.
Oh, I don't know those circumstances.
Well, if we look at tab 97, you'll see this is the direction from the, normally from the branch to all bodies of elders, and it deals with the subject of child molestation, and particularly if you look at the third paragraph.
Thank you.
Those who are appointed to privileges of service, such as elders and ministerial servants, are put in a position of trust. One who has extended privileges in the congregation is judged by others as being worthy of trust. This includes being more liberal in leaving children in their care and oversight. The congregation would be left unprotected if we prematurely appointed someone who was a child abuser as a ministerial or servant or elder. So there are circumstances, aren't there, where it's quite allowed for an elder or a ministerial servant to be alone with a child other than their own.
Well, this, my understanding of this was a warning to let elders know that families might be more trusting of a person and allow their children to be alone with somebody who was a ministerial servant or an elder.
So there's no prohibition on ministerial servants or elders being alone with the child in the congregation.
They're not meant to. It's not in terms of their rules. They're not supposed to meet alone with children.
Well, what rule can you point to?
It would take me a little bit of time, but that elders in particular are not supposed to meet alone with women or with children. So I would have to spend some time finding where that is.
Does anyone else know where that rule might be?
We'll find out, Your Honour. And
If we go on and look at paragraph 23, I think you've you've accepted that you identified the wrong reference there. Can you just give us the name of what the proper reference is? It's not the brief review of contemporary sexual offence and sexual abuse legislation in Australia.
No, it's the historical overview of...
Is that also a study that was done for this Royal Commission?
It was done for the Royal Commission,
Oh,
and it's an extensive study with the history as they describe the 1980s.
And then if we look at, still in that paragraph further down, 4 lines from the bottom, it says the article, that's referring to the article Help for Victims of Incest. The article tells the story of an elder who erred by telling a woman to just forget about the abuse and urges readers to listen and show compassion. After telling elders to be thoughtful, the article also points out that some victims of abuse may need to talk with an experienced professional counsellor. Now, insofar as it goes, that's of course correct, but there are limitations on what professional support or therapy that Jehovah's Witnesses can employ under their teachings, aren't there?
Yes?
For example, there would certainly be restrictions on a survivor, cautions or restrictions on a survivor from participating in group therapy.
And that part I don't know about. The only part I've ever heard is that they would recommend to choose someone who was respectful of their religious beliefs.
Okay, well, it's worth taking a quick look at that. That's at 120. That's tab 120, which is the shepherd, the flock, and it's at page 131, which is at ringtail 132. I beg your pardon, I've got the wrong reference there. It's at page 55. Page 55, paragraph 25. So you'll see the paragraph deals with, or says, do you have it?
I do.
There are times when in emotional distress, Christian may seek professional help. whether a Christian, and by reference to Christian there, it's a reference to a member of the Jehovah's Witness faith, is that right?
That's my understanding of it in this particular text.
Whether a Christian or his family pursues treatment from psychiatrist, psychologist, therapist is a personal decision. An elder should not assume the responsibility of recommending a specific practitioner. He may draw attention to or discuss material in the publications that provide cautions regarding therapies that may conflict with Bible principles, and various Watchtower references are given. And then it says, while participating in group therapy by a professional therapist, while participating in group therapy by a professional therapist is a matter for personal decision, there could be a revealing of confidential facts about other members of the Christian congregation during such sessions if the Christian does not exercise discretion. So you'll see there that participation in group therapy is certainly frowned upon, and there are restrictions with regard to it.
I saw it as it's frowned upon to talk about other people in group therapy, but that's my reading of it.
Well, it's hard to conceive of group therapy when one doesn't talk about what happened to one as a survivor. You would accept that.
Absolutely.
And if it was one's father or one's uncle or one's teacher or one's elder or one's ministerial servant, one wouldn't be able to get the benefit of the group therapy without saying it was who abused me.
Right. Right.
So there would be a very substantial restriction, according to this, on a witness's ability to participate in group therapy.
Yeah, it says it's a matter for personal decision and to use discretion, but I could certainly see your point.
And you would accept, of course, that group therapy, in the case of sexual abuse survivors, can be a very important form of therapy, depending on the particular case.
Oh, absolutely. No question about it.
In paragraph 26, you say that elders are instructed to report crimes according to the law. Do you see that?
Oh, I'm sorry. I thought you said I said.
Sorry,
yeah.
I'm in your, I beg your pardon, I was very unclear.
Okay.
I'm in your report now, paragraph 26.
Okay.
You see that? Elders are instructed to report crimes according to the law. And then in 27, you say bodies of elders have been instructed to follow the mandatory reporting laws of their state or country and to call the branch legal department for legal advice regarding reporting requirements if anyone reports an allegation of child sexual abuse to them. So just to get that straight, the instruction first is to contact the branch office. Is that right?
That's right.
And then if the branch office advises that there's a mandatory reporting requirement, they must then report. Is that right?
That's right.
So what you don't mean to imply in 26 is that generally elders are instructed to report by, according to the law, you mean when the law requires it?
Under mandatory reporting?
Yes. And in 33, your paragraph 33, that is. You say, regardless of the outcome, the deliberations of a judicial committee and the information they consider are kept confidential. And then you go on to say, like most Christian denominations, Jehovah's Witnesses strive to create a spiritual environment that allows opportunities for sinners and so on. Now, I mean, firstly, you appreciate, I take it, I think it's in your report, that a judicial committee must pass on the findings and significant information about them to the branch office.
Yes.
Yes. So insofar as there's confidentiality, it's not confidentiality to those who are dealing with it. It involves also giving it to others effectively at the country headquarters.
I just want to understand that when you say those who are involved, do you mean those?
The members of the Judicial Committee.
Maybe you could ask me again. I just have trouble following.
Yes. So when you say that the outcome and deliberations of the Judicial Committee and the information they consider are kept confidential,
Yes.
You don't mean they're kept confidential just to the members of the Judicial Committee?
No, I should say confidential, a need-to-know basis versus publicly reported.
Yes, and quite unlike the case of the Catholic sacrament of confession, for example.
The judicial committee itself would be different than a seal of confession in the Catholic organization.
Yes, the Catholic Church, it's between the penitent, I think is the correct word, and the priest, and it goes to no one else, not the bishop, not anyone.
That's correct.
And whilst in the pastoral work of an elder, there may be circumstances in which someone confesses in a cleansing of sin way, really it's quite different in a judicial committee, which is a fact-finding inquiry, isn't it?
Yes. For me, as long as there's more than 2 people in the room, it's not ordinarily considered a confession in that sort of technical sense.
Yes. So, Dr. Applewhite, just summing up then on that first section of your report dealing with issue number 3, I suggest that the Royal Commission cannot accept the opinion that you express in paragraph 36 as supported by the material presented by you.
In 35?
In 36.
In 36? Are you asking me if I agree with that
Well,
suggestion?
I'm giving, yes, or if you don't, I'm giving you the opportunity to respond to it, because that's what I'll submit in due course, and I need to be fair to you.
Okay. Well, the first work that I did in Australia was I went to Brisbane and Sydney and Adelaide, and there were educational programs that were opened up to anyone who wanted to participate. So there were people from social services and faith-based organizations and schools. And in that process, before I came to do those very first workshops, I did a review to see what was available. There's quite a bit of empirical research that's come out of Australia. I reviewed the empirical research that was here, as well as to review the documents that were available to religious organizations and schools. And so that's the review that I did. And I have tried my best to keep up with all the publications that have been part of religious organizations in terms of making sure that the recommendations that I do provided educational programs are meeting the standard of care. And if there are new things that have evolved or studies that have been published, to make sure that I review those before I offer recommendations. So that's the basis for the opinion.
Now, addressing in particularly the Jehovah's Witness procedure and practice insofar as it's set out in the documents about dealing with complaints or allegations of child sexual abuse. Now, the first step is that 2 elders are to investigate. Is that right? On an
Yes.
elder hearing of such an allegation,
Yes.
then 2 elders must investigate. And that includes interviewing the complainant.
Yes. If there's a complainant versus a witness, yes.
Those 2 elders, of course, necessarily men.
Yes.
And
Elders are all men.
And very often the complainant is a woman, the survivor, or a child.
I don't know the statistics. I don't know the percentages.
Well, you would have to accept that at least very often.
I can't imagine it being uncommon.
And, well, I can give you the statistics actually. I can give you the statistics, I'll come back to it. And then if there's sufficient evidence found, a judicial committee is formed. That's right, isn't it?
That's my understanding, yes.
And that's comprised of 3 elders.
There could be more, but yes, 3's ordinarily what would be expected.
Also necessarily men.
They would have to be men.
And they then would again interview or hear evidence from the witness survivor.
Are you talking about in current practice?
Yes.
In current practice, the survivor could write a letter. The survivor wouldn't necessarily have to meet with everyone together.
Well, that's in extraordinary circumstances, isn't it, if the survivor is far away?
Not my understanding.
Can you identify the origin of your statement with regard to current practice?
Sure. So if you go to the shepherd of the flock of God, also I think in your documents maybe called the Elder Handbook.
Yes, it's at tab 120.
So it would be paragraph 38.
Which page?
72. So it says, they're asking to begin with that someone, that it's loving for the witness to first confront the accused, but then it goes on to say that for the witness by himself to confront the accused may not be advisable in all cases. For example, if the witness and the accused were involved in sexual immorality together, or the witness was a victim of incest or rape by the accused, or is a child and the victim of sexual abuse. Or it may be that the witness is extremely timid.
That, as I understand it, is a statement about the survivor, in the context we're talking, approaching the abuser themselves, isn't it?
Yes. And as part of the investigation process.
Well, I'm not sure I understand that to be an investigation step. It's a step that may have consequences for the investigation, but it's being put there as an attempt to, I assume, have the abuser confess to the abuse. Is that right?
As leaving out the possibility that somebody who, or the likelihood that somebody who was sexually abused would have to confront the person.
Sorry?
Leaving out the person who was abused having to confront their offender.
In order to persuade or encourage the abuser to confess.
To confess, yes.
Yeah.
But the investigative stage is the next paragraph, isn't it? If the accused denies the accusation, the investigating elders should try and arrange a meeting with him and the accused together. And then it's got a note, if the accusation involves child sexual abuse and the victim is currently a minor, the elders should contact the branch office before arranging a meeting with the child and the alleged abuser. The standard is still to do two things. One, the investigating elders must interview the victim, not so?
Yes.
And the standard, with exceptions allowed, possibly from the branch office, is for that meeting to include the survivor confronting the accused.
I believe we would probably have to go to the letter to the elders from October of 2012.
Well, just let me make sure we're taking our steps carefully, though.
Okay.
39, as I presently understand it, requires the child or the abused, the survivor, to be present with the abuser. And if that doesn't happen, then the matter's to be left, as it says, in Jehovah's hands. Is that right?
Just a moment. I'm sorry. I just want to make sure I get the reference right. And you're on which paragraph?
39.
Okay.
So if the accused denies, try to arrange a meeting. And then if the accuser or the accused is unwilling to meet or continues to deny the accusation of a single witness, then it's left not resolved.
From spiritual standpoint. I mean, from my perspective, I mean, I know we're talking about what happens
We're
within
talking
your-
about factual matters here.
Right, but there's also the investigation. I mean, if this has a report, there may be a separate investigation going on as well.
I'm sorry?
If this has been reported to the police, then there may be a separate
Well, if it's gone to
investigation
the
going on as
police,
well.
but that's different to what we're talking about here.
Yes,
We're talking about the Jehovah's Witness process.
right.
And you'd see this as, if you have the hard copy in front of you, you'll see this as part of the evidence establishing the wrongdoing process. That's from paragraph 37 onwards. And then, if there is sufficient evidence, then it goes to a judicial committee. And that's at page 89. And you'll see in paragraph 1, it's provided in bold that the elders of the Judicial Committee should convey their desire to be helpful and try to put the accused at ease. No particular emphasis on putting the survivor at ease, is there?
I don't know that there's an assumption that the survivor would be in this meeting.
Perhaps not at the start. But in paragraph 2, if the accused attends that he is innocent, the witnesses to the wrongdoing should be presented and their testimony should be given in the presence of the accused. So in other words, if the survivor is one of the witnesses, then she, as it usually is, would have to give evidence in the presence of the 3-member judicial committee and the accused.
And that's when their testimony could be given by letter as well in today's practice.
Well, we carry on. It says, however, it may be that the witnesses live a great distance away or for some reason are not able to be physically present. If so, their testimony may be presented in the hearing of the accused by a secure phone call or perhaps submitting in writing and read to the accused. That's what you're referring to, isn't it?
Not just that, but these procedures are meant for any serious wrongdoing. And my understanding is that if someone is actually going through this procedure and with respect to sexual abuse, that they receive particular guidance as well. So this is for any serious wrongdoing. And
Is that extra guidance included in a document?
there's the document that was and I don't know the 3 names, but the one who provided the information about the legal department at the branch office. That would be
You mean the witness statement?
the witness statement. And also there's the letter from 2012, October of 2012, that lays out some of those particular procedures.
Well, I'll go to the letter in a moment.
So are you saying that these procedures have been modified by some other instruction?
Amended by some other instruction. So that would be the letter that comes out that says...
So the letter says don't follow this procedure, follow a different procedure?
It's the same procedure, but helping people understand that if it's a case of sexual abuse, it's not the same thing as someone who transgresses in some other way, and it needs to be handled more sensitively.
But I'm not sure. Are they nevertheless, in handling it sensitively, to follow these procedures that we're looking at the moment, or to follow a different procedure?
It's the same basic procedure.
Right. So they haven't sat down and looked at this document to see whether it should have a separate section in relation to sexual abuse allegations?
Well, they'd have a section called child abuse in this book.
Yeah.
On page 131.
But here we're looking at judicial hearing procedures.
Right.
They haven't sat down and written what the procedure should be in this document for child abuse cases.
Not as far as I know.
Many organisations do that these days, don't they?
How they,
how they handle complaints in relation to sexual abuse of children?
very few religious organizations have procedures that relate to how they're going to handle the transgressions of individual members of a congregation. So the parishioners or the faithful, so to speak, there are very few organizations that have procedures for what exactly do you do.
That's true, but many have procedures to enable them to effectively respond to a complaint that someone's been abused, don't they?
Yes.
Yeah. And in every sense, that's the most important thing the institution can do, isn't it? Effectively respond to the person who says they've been abused.
Yes,
I mean, that should be the priority, shouldn't it?
absolutely.
Yeah.
Just before I take you to the 1 October 2012 letter, you'll observe also in paragraph 3, it says observers should not be present for moral support. Do you see that?
Yeah, this is actually saying that they don't want to hear from a lot of witnesses who are giving character testimony about the accused. So that, I mean, this particular section is really speaking more about moral support for the accused.
Well, even if that's so, there's
No,
certainly
I'm sorry, I don't understand that. This is talking about relevant testimony from witnesses. It excludes character evidence. Witnesses should not hear the evidence of the other.
Mm-hmm.
But then it talks about observers should not be present for moral support. They're different concepts,
I see.
aren't they?
Yes.
What Mr. Stewart's putting to you is that this would exclude a survivor from having someone there to provide moral support. That's right, isn't it?
I'm not sure what happens in each case.
No, but that's what these words say, isn't it?
Mm-hmm. It does.
And then if we take a look at the document you referred to, it's at tab 124. I'm sure we can give you a hard copy, which is the 1 October 2012 letter.
Oh, yes. Okay.
Is there any part of that letter you like to identify which moderates or ameliorates or otherwise changes the process we've just been looking at?
Sorry, I'll just wait till I get a copy of the letter. Thank you. No, that's okay. So I've just been reviewing the letter that is the procedural amendment to the Elder Handbook. And I remember that we were talking about a topic and I referenced this letter, but then we moved on from that topic and now I don't recall what it was that we were discussing. Do you?
You mean when we referenced this letter?
Yes.
It was the specific procedure of investigation by 2 elders, interviewing the complainant, going on to the judicial committee, requiring the witness of the complainant or the evidence of the complainant to be given in the face of the accused, and no moral support being allowed.
So the piece of moral support I don't think is referenced in here. It provides the process of calling the legal department for specific advice under circumstances that range from abuse being alleged by one witness to happening long ago to the victim now being an adult, and saying that they'll give them advice based on the law, and then they'll also my understanding is that they'll be transferred to the service department, and that it's the service department that provides information about caring for the person who may have been abused.
Okay.
And
what about the procedure
right.
that's referred to in the document that's under the heading Judicial Hearing Procedure? Is that modified in any way?
The only distinction that I would say in terms of procedural is that instead of there being an elder who, that they would decide who's going to be on the judicial committee, the circuit overseer is supposed to determine who within the circuit is most qualified to oversee the judicial committee. So rather than just have the elders say, oh, we have this, we're going to form our own judicial committee, the circuit overseer is supposed to assign someone to that.
But the process remains that which is set out
That's my
in
understanding.
the document.
Yes.
So,
Now that process doesn't meet the best practice elements that you identified in your testimony earlier, does it? It's not child or survivor centered, is it?
Well, it can be. I mean, if it's handled sensitively, it certainly can be.
Well, to require a survivor of sexual abuse to have to disclose the intimate details of what happened to her, which is necessarily of a sexual nature, to firstly 2 men and then secondly to 3 men, and in the face of her accused, that's in no way child or survivor centered, is it?
In the investigation, if the investigation is handled sensitively, or the questions are asked sensitively, particularly if it's somebody who the person is comfortable with, it could be. It could also be not handled well at all.
Doctor, are you familiar with the work that's been done in Australia in the civil justice process in relation to the prosecution of these types of offences?
In terms of how survivors are?
How witnesses are handled, and particularly how survivors are managed. Are you familiar with those processes?
I am.
And are you familiar with one of the fundamentals being that the abused person need not confront the abuser in that scenario?
Absolutely.
This process offends against that principle clearly, doesn't it?
My understanding is that they can write a letter and that there doesn't have to be a confrontation at all.
We just looked at all those processes.
Yes.
Well, maybe, I don't know where you get that understanding, whether someone told you that or what, but you restricted your report and your evidence now to what the documents say, and the documents don't say that, do they?
So you're saying that in the judicial process today, that evidence can't be received from a witness through a letter?
Well, according to these documents, yes, I'm saying that. There may be some Judicial Committee somewhere.
Well, I think it probably should be put slightly differently. The words are, however, it may be that the witnesses live a great distance away. You have to ask yourself what is meant by witnesses there, whether that includes the survivor, or for some reason are not able to be physically present. So we're talking about an exception.
Okay.
You understand?
I do.
Otherwise, the procedure contemplates what Mr. Stewart's been putting to you. And that is that the girl or woman would have to confront ultimately 3 men in the presence of the abuser and without any moral support. So on her own. Now, is that a good practice?
Absolutely not.
No.
I want to be clear. If it turns out that the practice that they have today doesn't allow someone to write a letter, and they have to confront their offender, and they have to sit in a room with no support, it's not going to meet the standards of care. I didn't understand that that's the process, and there are probably people more qualified than I am to say whether it is, but it wouldn't meet the standard of care if that's the fact.
Well, the difficulty for us is that you have proffered to us your written report in relation to all of this.
Yes.
We're trying to work out whether or not what you've said is something that we, as the Commission, should accept, carrying with it, of course, the consequence that if we say it's a good practice, then others might follow it. Do you understand?
Absolutely, and in no way am I trying to say that that's a good practice.
No.
And there's also this requirement, the 2-witness rule. You're familiar with that? That's actually reconfirmed in paragraph 11 of that 1 October 2012 letter with reference to the scriptures, that the 2-witness rule very much applies. That's not best practice, is it?
Again, the difficulty is that there are so few organizations that would be dealing with individuals who are part of a congregation. I will say that if we were to look at other religious organizations and ask the question whether, if they went through a process, an internal ecclesiastical process, and had 2 witnesses or a confession, and they took that to be true enough to remove someone from ministry, then there are a lot of situations that wouldn't have gone any farther.
That
piece.
Sorry.
In an ideal world, we would like for there to be able to be one person saying so. It's difficult in these kinds of situations to sort that out when there's one person and no corroborating evidence.
Doctor, the issue, of course, I understand how you put it in terms of its context, but the issue in the context of the survivor is that the obligation that a member of the Jehovah's Witness has is to report misconduct.
Yes.
So that the obligation would fall upon the survivor to report, wouldn't it?
To report if they had experienced abuse?
Yeah.
Or if they knew about abuse? Yes.
That would be their obligation.
You mean within the organization?
Yes.
Yes.
Yeah. And then there's a process that identifies ultimately whether the allegation is accepted or not.
Mm-hmm.
Now, do you see that there is or maybe a problem for a survivor who has the obligation to report sexual abuse, which very often will happen in private, most often will happen in private,
Yes.
and find that because there's not another witness, their allegation is not accepted? Do you see that might have real difficulties for the survivor?
Absolutely.
Is it a good process to allow that mandatory obligation to report to be accompanied by a circumstance where, in many cases, the result will be, because of the absence of another witness, that the allegation is not established?
It is. There are going to be cases where it goes badly. I think for me, because for me, I really believe that religious organizations should be required to report to the law. That's a piece of it that it's hard for me to sort that piece out, because there's the ecclesiastical process. And in truth, looking at many instances of abuse in religious organizations, there was way more evidence than just two witnesses, and way more evidence than just a confession even. And they still didn't act upon it. And so if they follow through with this, probably they're going to act on more cases than I would see in a lot of religious organizations. But the overlay for me is that I would hope that we're going towards also a mandatory reporting requirement, so that they don't have the option to not also report to the police.
Well, you're right. There will be many religious organisations which don't set out to determine whether or not the allegation is well-founded, and the matter will be dealt with by the civil courts. But is there a problem when you do have a process that does set out to identify whether the allegation is well-founded, which then can miscarry, as we would conventionally understand it, as this process can? That's the problem, isn't it? You've set up an obligation to report the abuse, then a process to determine the truth, if you like, of that allegation, which I think you and I are on the same ground. We agree does not accord with what one would normally see as the appropriate way to resolve a dispute of that nature. The allegation's denied. Is that right?
Yes.
I don't know what we can do about it, but you see there's a real problem.
It is.
Yeah.
And it is.
I think we might take the luncheon adjournment now, Sister.
All stand.